Hi everyone, let's talk about intellectual property. In this lesson we're going to define what intellectual property is. We're going to define what a trade secret is, describe the misappropriation of a trade secret. We'll describe how an invention can be patented and the penalties for patent infringement. We'll describe the items that can be copyrighted and describe the penalties for copyright infringement. We'll define trademark and service mark, and we'll describe the penalties for trademark infringement. And finally, we'll define dilution and describe the forms of dilution of a trademark. Setting the stage, intellectual property is property that is developed through an intellectual and creative process. It falls into a category of property known as intangible property, having intangible rights. The big four categories here are trade secrets, patents, copyrights, and trademarks. It's very difficult to downplay how important intellectual property is for the economy of the United States. One of the things we do very well is invent and create things. And if you're going to invent and create things, you need to have at least some period of time where you can make money off the things that you invent and create. So that's what intellectual property is all about. Taking them one at a time, a trade secret. A trade secret is not something you apply for. It is not something that the government necessarily grants you. It's just something your business does that's highly valuable to you, you consider to be very important to your business model, and you don't want other businesses to find out what that thing is. That's a trade secret. So it can be a product formula. People, there's always this legend of the secret formula to Coca-Cola or to KFC's spices combination that makes their chicken so good. So that would be product formula. It could be a product, a pattern. It could be a design of something. It could be some collection or compilation of data. Thinking about, maybe client lists if you're a salesperson. It could be these customer lists or any other business secret, something that's very important to you and your business and that you don't want other people to know about because it might give them your competitive advantage. The Uniform Trade Secrets Act was an attempt to create a uniform set of rules that all states could adopt. North Carolina has not yet accepted this, but we do have our own version of legislation that will protect trade secrets. The state unfair competition laws allow the owner of a trade secret to bring a lawsuit for misappropriation against anyone who steals a trade secret. Misappropriation is that word that we give that means stealing. Well, it just means stealing, but in this context of a trade secret. So a defendant must have obtained the trade secret through unlawful means, stealing it or taking it without permission or hacking into a computer or something like that. A trade secret unprotected by the owner is not subject to legal protection. So if you are just if you're not taking steps to actually protect that secret, if you're just leaving it open on a desk or posting it on Facebook or something like that, then it's not a protected trade secret. You can follow the links there to find the North Carolina Trade Secrets Protection Act and the U.S. Defend Trade Secrets Act of 2016 if you're interested in following up on that and reading the actual laws. Reverse engineering is the process of taking somebody's product, disassembling it, taking it apart, examining its components, and then creating your own based on what you've learned. That's reverse engineering. Reverse engineering is not considered to be misappropriation of a trade secret. It's just me looking at how something is made and then making my own version of that thing. So this happens all the time. You can reverse engineer and create your own product, but of course you can't use somebody else's trademarked name or symbol or logo or anything like that. And if they have a patent on a design, then you can't infringe on that patent. But we haven't gotten there yet. We're just still talking about trade secrets. Misappropriation of a trade secret. If somebody does misappropriate your trade secret, they've stolen it, and are using it to gain your competitive advantage, you as the owner can bring a civil lawsuit against someone who has done this. If I am successful, I can recover any profits that were made by the offender. I can recover any other damages that I might have suffered, maybe through lost sales or whatever other damages I suffer. I can also obtain an injunction where the court prohibits the offender from divulging or using the trade secret. The Economic Espionage Act is a federal law that makes it a federal crime for any person to convert a trade secret to his or her benefit or the benefit of others, or performing the above knowing or intending to cause injury to the owner of the trade secret. So this is important in addressing computer and internet espionage. Businesses hacking into other businesses' computers, trying to steal trade secrets. This would be considered economic espionage. No longer are we in the realm just of civil penalties of just paying money, but now we're in criminal law here where somebody could actually be imprisoned for doing this type of thing. So it really tries to strengthen that intellectual property protection for trade secrets. A patent is a grant by the federal government to the inventor of an invention for the exclusive right to use, sell, or license the invention for a limited amount of time, usually talking about 15 or 20 years here. The intent is to provide an incentive for inventors to make their inventions public. It protects patented inventions from patent infringement. Federal patent law is exclusive to the federal government. There are no state patent laws. The federal government retains the exclusive right to hear patent infringement lawsuits. I'll give you a link in the PowerPoint here to review a relatively recent patent lawsuit where a so-called patent troll had acquired a patent and tried to use it against many popular podcasters, demanding that they pay them royalties or else be sued. It was resolved in the favor of the podcasters. A patent troll is not an official legal term, but it's a popular term given to a company that goes around acquiring old patents and then trying to just apply them in contexts where they really don't belong, just to try to sue people to get them to pay money. Not a particularly great side of business, but it does happen. The right to patents are granted in the United States Constitution. The federal patent statute of 1952 establishes the requirements for obtaining a patent and protects patented inventions from infringement. The U.S. Patent and Trademark Office is the federal office that evaluates patent applications and grants more than 300,000 patents per year. The U.S. Court of Appeals for the Federal Circuit is the one that hears appeals from the Board of Patent Appeals and Interferences and federal court concerning patent issues. So if you invent something and you want to try to apply for a patent, you'll file with the PTO, Patent and Trademark Office, in Washington, D.C. You have to your application has to contain a written description of the invention, sometimes even graphic sketches of it. The PTO must make a decision whether to grant the patent within 3 years from the date of filing. If time is really of the essence, it can grant priority to patent applications for products, processes, or technologies. It can also issue a provisional application that an inventor can file with the PTO to obtain 3 months to prepare a final patent application. Sometimes if you invent something and you're really racing against the clock to get that patent and make sure nobody else invents the same thing as you, then the provisional application can help out. There are lots of reasons why a patent may or may not be granted. One of the reasons why it might not be granted is what we call prior art, meaning that a patent could be denied if the subject matter appears in prior art, which can be a reference, description, or event in the past that shows the idea is not new. So if somebody else came up with that idea first and we can demonstrate that, then your idea is not new, and you probably won't get a patent for it. If you apply for a patent and you get rejected, you can appeal that decision. That would go to the Patent Trial and Appeal Board. They're the ones that review adverse decisions by patent examiners, and they conduct other patent challenge proceedings. If your patent is actually issued, you'll get a patent number, which will be the number assigned to the invention when the patent is granted. So things that can be patented: machines, processes, compositions of matter, improvements to existing machines, processes, or compositions of matter, designs for an article of manufacture, asexually reproduced plants, living material invented by a person. Things that are not patentable: laws of nature. I can't patent gravity. Abstract ideas that haven't been actually reduced to something that is commercially viable. Naturally occurring substances, so I can't go and just patent carbon. Mathematical formulas can't be patented, and scientific principles can't be patented. The requirements for actually obtaining a patent is that we have patentable subject matter. It has to be novel, it has to be useful, and it has to be non-obvious. As an example, this case is a very important one as we're sort of wrestling with the idea of what can and cannot be patented, especially as we're learning more about the human genome and becoming more able to edit DNA. A biotech firm called Myriad Genetics found the location in the human genome of two genes known as BRCA1 and BRCA2. Mutations in those can dramatically increase a woman's risk of developing breast cancer later on. So they applied for a patent, and that patent was issued on finding those two sections of DNA. The part of the science community challenged this and said the patent shouldn't have been granted because it's part of nature. So this reaches the Supreme Court of the United States to try to figure out, can we patent segments of human DNA? The language of the court was that laws of nature, natural phenomena, and abstract ideas are not patentable. It's undisputed that Myriad did not create or alter any of the genetic information encoded in the BRCA1 and 2 genes. The location and order of the nucleotides existed in nature before Myriad found them. Nor did Myriad create or alter the genetic structure of DNA. Instead, Myriad's principal contribution was uncovering the precise location and genetic sequence of the BRCA1 and 2 genes. Myriad did not create anything. To be sure, it found an important and useful gene, but separating that gene from its surrounding genetic material is not an act of invention. So the Supreme Court said that they couldn't patent these two genes that they had found. It's hard to know exactly what repercussions that will have later on. The argument of the biotech firm is that they need to be able to get these patents so they can justify the investment it takes to create gene therapies that would help prevent diseases later on. The argument of the scientific community is that if we allow companies to patent parts of human DNA, then it will make it much harder for anybody else to go in and develop these kinds of therapies, and we might be getting into some dangerous territory if companies can patent certain parts of human DNA. So that might not be the last case we see about this kind of thing, but certainly it's the controlling case as of now. The Leahy-Smith America Invents Act is a federal statute that significantly amended federal patent law. Prior to this, the rule we operated on was the first to invent rules. So the first person to invent a thing would get the patent to it. What this act did was created the first to file rule, saying that the first party that files for a patent on an invention receives the patent. So sometimes we see two people apply for a patent relatively close to one another and have to decide who actually gets that patent. Was the first person to file for the patent, or was it the first person to actually invent the thing? And so for now, it's the first to file. If you are awarded a utility patent, that's good for 20 years from the time that the application is filed. So you get 20 years of legal protection, saying you're the only person who can use, create, and sell that particular invention. Other people can invent things that are sort of similar to it, but it has to be different enough not to violate that patent. In fact, a lot of companies hire people that they dub patent busters, who go in and try to create something sort of generic to like a name brand thing, but that doesn't violate the patent, and maybe they can sell it for cheaper. It's a whole industry. A very important segment of our economy where patents come into play, and we hear stories about this pretty regularly, are for pharmaceuticals. So if a drug company invents some pharmaceutical drug that treats or prevents some disease, they get a utility patent on that, and then they have 20 years of exclusive right to sell that drug before it becomes part of the public domain where anybody can create and sell that thing. Patent infringement occurs when somebody makes unauthorized use of somebody else's patent. So if I'm successful, the plaintiff may recover money damages equal to the reasonable royalty rate. Other damages that are caused by the infringement, I could get an order for destruction of infringing articles. I can get an injunction against the infringer from creating or selling any more of those infringing products. And if I can show that the infringement was intentional, I could be eligible for treble damages, which is a legal term that means triple damages, which really raises the stakes. If they show that I was intentionally infringing on a patent, I could get triple the amount of damages that the plaintiff actually suffered. A design patent, we talked about utility patents, but a design patent is a different kind that covers the ornamental and non-functional design of an item. If I'm granted one of those, it's valid for 14 years. This Samsung Electronics versus Apple was part of a very lengthy legal dispute between Apple and Samsung regarding the design of phones. Apple claimed and had patents on various parts of a phone, including a flat face with rounded edges with a grid of icons, which, if that sounds familiar, it's because pretty much every phone by every manufacturer operates that way. But there were a lot of lawsuits about this regarding the design and operation and function of phones, especially in the early days of smartphones, where we're trying to figure out if anybody infringed on anybody else's patents. A key part of this lawsuit was Apple had won I think a $500 million judgment against Samsung, which covered the sales of all of their infringing phones. And Samsung claimed that Apple shouldn't have been awarded damages on the sale of the entire phone, but only on the sale of the infringing components, which would have been much less than the entire sale of the phone. It went to the Supreme Court to try to decide. The Supreme Court said that really it could be either. It could be on the sale of the entire phone or on just the infringing components. The way this lawsuit shook out is that there was a back and forth over many years. And finally, in 2018, the companies arrived at some settlement with undisclosed terms, so we're not really sure how they settled it and what we arrived at, but It's pretty easy to see that a lot of phones look very similar. They operate very similarly. So maybe it's just cheaper for everybody to have phones that operate somewhat similarly and differentiate in other ways, rather than spending all this money fighting it out in court. Okay, so we've talked about trade secrets. We've talked about patents. Let's talk about copyrights. So copyrights are what give the legal right to an author of qualifying subject matter, exclusive right to publish, produce, sell, license, and distribute the work. In other words, if I write a song or if I create a piece of art, a copyright is the thing that will give me the exclusive right to make, produce, sell, license, and distribute that song or that piece of art or that movie or that TV show, whatever the artwork is. The Copyright Revision Act of 1976 established the requirements for obtaining a copyright and protects copyrighted works from infringement. So the requirements for a valid copyright. It has to be a tangible writing. So tangible writing is defined and interpreted very broadly. So it can be a book, a lecture, slides, greeting cards, pictures, TV show, movie, artwork, etc. It has to be affixed to a tangible or permanent medium. So that can be audio, video, typed words. It really is interpreted quite broadly. So tangible doesn't really have the meaning that we normally think, something that you can touch. It has a much broader meaning here. It has to be original. So I can't just copy somebody else's work and then get a copyright on it. That person will probably be able to show that they created the work before me. And the person who created it first is the one that has the copyright on it. So as soon as you affix your original copyrightable material to a tangible medium, you have a copyright. You don't necessarily have to apply for a copyright if I'm the one that created it. And once I affix it to a tangible medium, such as recording it or creating video or creating the work of art on a canvas, then I have the copyright to it. I can, however, register my copyright with the government. I don't necessarily have to do this, but it might give me extended legal protection, and it allows me to use the little Circle C symbol. The Berne Convention is an international copyright treaty that eliminated the need to use the Circle C or the word copyright on a copyrighted work. If a person creates it, they have the copyright, even if they don't use the little symbol. I can register my copyright with the U.S. Copyright Office. It is permissive, it's voluntary. It can be done at any time during the term of the copyright. Registration gives me the right to obtain statutory damages for copyright infringement. So rather than me demonstrating exactly how much I think I lost because of an infringement, it might be that the statute spells out exactly how much I can achieve in as far as damages go. And it allows me to sue, at least in federal court, for copyright infringement. For an example case, we have Star Athletica versus Varsity Brands. This went to the Supreme Court of the United States in 2017. Varsity Brands was a company that made cheerleading uniforms and put designs and pictures and arrangements of symbols and stars and things on the cheerleading uniforms. Star Athletica sold cheerleading uniforms that did similar things, and Varsity accused Star Athletica of violating their copyright on the pictures and designs that were put on the uniforms. So going into this, we have to understand that you can't copyright an article of clothing, but you can copyright designs and artistic works. So one thing the court had to decide was, can you separate the useful item, which being the cheerleading uniform, from the designs that are put on it? And ultimately the court decided that yes, you can. So while Varsity couldn't copyright the cheerleading uniform itself, it could copyright the designs that it was putting on them, and then sue Star Athletica for infringing on their copyrighted work. So how long is a copyright good for? The Copyright Term Extension Act of 1998 provides that individuals are granted copyright protection for their entire lifetime, and then 70 years after they die. If a copyright is owned by a business, that's protected for 120 years from the year of creation, or 95 years from the year of first publication, whichever expires first. The Copyright Term Extension Act is sometimes called the Mickey Mouse Act because Disney Corp was one of the main pushers for extending the term of a copyright, because the copyright for Mickey Mouse was set to expire. Interestingly enough, the copyright for Mickey Mouse is set to expire here pretty soon again, so some people thought that Disney might push for another extension of copyright. They haven't so far, and they haven't indicated that they're going to, so they might just let that expire. And then at that point, we'll see what happens. But quite a long time for copyright protection. An individual's lifetime plus 70 years, or 120 years for a business-owned copyright. Plenty of time to make money on your created work. Copyright infringement happens when a party copies a substantial and material part of the plaintiff's copyrighted work without permission. So a successful plaintiff can recover profit made by the defendant from the infringement, damages suffered by the plaintiff. They could get an order requiring impoundment and destruction of infringing material, and they can get the court to issue an injunction preventing future infringement. In this case, Broadcast Music Incorporated, otherwise known as BMI, versus McDade & Sons. McDade & Sons owned a small bar where they had live bands come in and play music. BMI is a company that represents a lot of artists and owns a lot of copyrights to a lot of music. If you've ever been at a bar or restaurant and they're playing music, and if you've ever wondered if they have to pay anybody to play that music, the answer is yes, they're at least supposed to. So BMI and another company named ASCAP are two of the major companies that own a lot of the copyrights for a lot of songs out there. And if a restaurant's going to play that music, then they need to pay royalties to the artists. If they don't, if they get caught, they can get sued. So it's kind of a risk that some restaurants take. But anyway, so BMI sent a representative out. They send representatives out to bars and restaurants just to see who's playing music and whether or not they've paid for that. And they discovered that McDade & Sons were allowing our bands to play copyrighted songs, but they hadn't paid any royalties, so they sued them. McDade & Sons said that they weren't the ones that performed the music, so they shouldn't be sued, and also they shouldn't be sued because they're a very small business. The court did not agree with that and found that copyrights give artists the exclusive rights to publish, perform, and sell their music, so they should have paid that money. So what if somebody accuses me of copyright infringements, what defenses do I have available to me? One big defense is called the fair use doctrine. It permits certain limited authorized use of copyrighted materials. Generally, fair use will be interpreted pretty narrowly, so just tread carefully here. Some examples of protected use are quoting for review, criticism, or scholarly work. Obviously, I can't copy the entire work, but small snippets that are used to either review, criticize, or in scholarly work. If I use part of that work as parody or satire, then that can also count as fair use. One of the biggest parody and satire artists in the world is Weird Al Yankovic, who used a lot of artist music to create different lyrics that are just kind of funny. even though he could have claimed fair use and maybe not paid the original artist for using their music, he's just a really nice guy and actually paid them anyway, just to maintain good relationships. We can use copyrighted works, or at least a brief quotation of them in a news report. Teachers or students are allowed to reproduce small parts of copyrighted works to illustrate a lesson. And there's also protection for incidental reproduction of work in a legislative or judicial proceeding if we're talking about some copyrighted work and have to either quote or play part of a song or something like that. That would be protected under fair use. The No Electronic Theft Act, or NET Act, protects against willful infringement of copyright and declares that to be a crime. Makes it a federal crime to reproduce copyrighted electronic works. The Digital Millennium Copyright Act, otherwise known as the DMCA, prohibits unauthorized access to copyrighted digital works by circumventing the wrapper. Wrapper here just meaning a digital wrapper. There's always been a race between digital pirates and copyright owners, content owners. So, they would encrypt CDs or DVDs to help try to prevent people from copying those. And then hackers would go in and figure out how to circumvent that encryption. So that would be the wrapper they're talking about there. So we've talked about trade secrets, patents, copyrights. Now let's talk about trademark. So a trademark is the symbol, the name, the word, logo, design, service that is unique to an individual business. It helps identify in the minds of a consumer if that is genuinely the product of that business. It helps them recognize the logo to identify where the business is. It can be all of these things that are unique to a business. We see trademarks everywhere. It could be the golden arches of McDonald's. It can be the brand name of Walmart. It can be really anything. But these are all protected under trademarks. The Lanham Act, the Lanham Trademark Act, is a federal law that protects the owner's investment and goodwill in a trademark and prevents consumer confusion. So to register a mark, I register with the Patent and Trade Office in Washington, D.C. If it has been used in commerce, and I can register 6 months prior to actually using it. I can register that trademark. Now, if I don't use it within that 6 months, I will give up the rights to that trademark. If a third party opposes to me getting that trademark, they can challenge that and say that the trademark should not be issued. This happens quite frequently. I think LeBron James tried to trademark the term Taco Tuesday. Kylie Jenner tried to trademark the name Kylie for sale of cosmetics, and those were successfully challenged, so the trademarks were not issued. So the kind of thing happens all the time. The circle R symbol is the symbol that designates a trademark that has been registered with the U.S. Patent and Trademark Office. The symbol or the letters TM, that's a symbol designating an owner's legal claim to a trademark that hasn't been successfully registered yet. So I don't have to go through the PTO to use TM, but I haven't registered that mark yet. The symbol SM designates a service mark. So a service mark is a little bit different than a trademark. Trademark is applied to a symbol or logo for a product. A service mark for a service business. There are also certification marks if we're some kind of, let's say we're going to call our product certified organic. There might be some body out there that regulates what actually qualifies as something being considered certified organic, and to use their mark, that would be a certification mark. To successfully claim a trademark, I have to show that there is distinctiveness or a secondary meaning. Being distinctive means that the word or the design is unique, and having a secondary meaning that, and even an ordinary term can become a brand name if it acquires a secondary meaning. So think about, Target. Obviously, the word Target has been around for a long time, but Target Corporation has used it, and it's acquired a secondary meaning, meaning the name of their retail stores, so that can become a trademarked name. So I can't open another similar retail business and call it Target. Some marks that cannot be registered as trademarks: flags or coat of arms of the United States or of any state, municipality, or foreign nation. Can't trademark the flag, the U.S. flag or the North Carolina flag. A mark that is considered to be immoral or scandalous. There was a very famous case about a band called The Slants who applied for a trademark to their band name, and they were rejected because the term slants had been used in the past as a slur against Asian people. You should also know that the band was comprised of entirely Asian people. And they had a long drawn-out fight that went all the way to the Supreme Court to figure out whether they could actually use their name as a trademarked name, and they eventually won. It just took a lot of time and money. Geographical names standing alone, so I can't just trademark North Carolina or trademark the United States. There would have to be something else to it. A surname standing alone, like a person's last name, just standing alone without something else. Any mark that resembles a mark that's already registered with the federal PTO also can't be trademarked. Trademark infringement is the unauthorized use of another person's or business's trademark. I have to prove that the defendant infringed the plaintiff's mark by using it in an unauthorized manner, and that use is likely to cause confusion, mistake, or deception of the public on the origin of goods or services. And this makes a lot of sense. If I've taken the time and effort and investment to create a business and created my own business name and logo, it would be extremely unfair for another business to come in and copy all of my business name and logos and everything and sell their own products. If I failed to use that mark for some period of time, the trademark could be at risk of abandonment. If I haven't used it for 3 consecutive years, there is the presumption that I have abandoned that mark, and then somebody else could pick it up and use it. A generic name is a mark, a former trademark that has become a common term for a product or service and has therefore lost its trademark protection. At that point, the name becomes descriptive rather than distinctive. Key lesson there being that if you have a trademarked name or symbol, logo, whatever the trademark is, you have to actively protect that name so it doesn't become generic. I'll give you some examples of things that used to have trademark protection but that just became generic over time because people just started using them in a generic manner and the company didn't protect it. So aspirin was invented by the Bayer Corporation, but over time it just became a generic name. So now any generic manufacturer can put the word aspirin on their bottles. The term App Store was originally used by Apple Corp, and then there was a big fight between Apple and Amazon over whether or not you could trademark the term App Store. Apple eventually just abandoned defending it, and so now any company can use the term App Store. Escalator, trampoline, thermos, yo-yo, zipper, laundromat, linoleum, these were all brand names, trademarked names at one point, but that just became generic through use over time. The Federal Trademark Dilution Act of 1995 protects famous marks from dilution, erosion, blurring, or tarnishing. a use by another party is actionable under the Act if it is commercial and if it causes dilution of distinctive quality of the mark. So if somebody creates a mark that's substantially similar to mine that would cause confusion, that would be blurring. It's just sort of blurring the lines between consumers not being able to really tell which product is one company's versus another, or tarnishment, which would cause a negative perception of my brand. So that the Federal Trademark Dilution Act of 1995 tries to protect or provide some protection against blurring and tarnishment. That act was subsequently revised to say that a dilution plaintiff doesn't need to show that it has suffered actual harm. It just needs to show that there is enough of a likelihood of dilution to grant me some protection. The fundamental requirements that the holder of the mark must prove are that the mark is famous, there was a use by the other party that was commercial in nature, and then that use causes a likelihood of trademark dilution. That was pretty key, because otherwise I would have to definitely prove that I was harmed in some way, and that can be difficult to do just by claiming that, I lost sales. That might be hard to really prove. So this allows us to say that there's enough of a chance of trademark dilution that we need to prevent the other party from that use. This is the case that actually triggered the Trademark Dilution Revision Act. There was a company called V-Secret Catalog that actually V-Secret and Victoria's Secret are part of the same company. I think everybody knows what Victoria's Secret does. They sell women's lingerie. You see the stores all over the place, and they operate a pretty successful online business. But there was another company who started using the name Victor's Secret and Victor's Little Secret. They operated a store that sold adult videos, sex toys, and things of that nature. And so Victoria's Secret thought that them using Victor's Secret instead of Victoria's Secret was close enough to cause blurring and tarnishment of their brand name. So they sued, and the Supreme Court said that since they couldn't show that there was actual dilution of the trademarked name, that they couldn't win anything. And people in Congress didn't like this, so sort of to overturn the Supreme Court decision, they passed the Trademark Dilution Revision Act, and then they went back to court, and then the court decided that, well, under the new Revision Act, since there's a substantial likelihood of dilution, that Victoria's Secret should be awarded damages. So we see this sometimes where even if a court and even if the Supreme Court makes a decision on something, if that decision is unpopular enough, Congress can go in and pass a law that would undo the decision that the court just rendered. So it's one of those cool things about law where you see the interplay between the branches of government. That's it for this lesson. I hope you all have a great